But generally speaking, contempt of court is defined as any act which is calculated to embarrass, hinder, or obstruct a court in the administration of justice, or which is calculated to lessen the authority or dignity of a court.
Yeah, you could literally, like, that's the awesome power that courts technically have. Like, this is why it's insane. If the Trump administration is like, no.
Every day.
I kind of want to watch this LegalEagle video. What happens when he ignores court orders? This is precisely the case that may happen.
Lawyers live by one ironclad rule. When the judge tells us to do something, we do it. That doesn't mean we always like it, and it doesn't mean we won't try to find other arguments to achieve the same ends. We're kind of like teenagers in that way. But at the end of the day, we roll our eyes privately and comply with what the judge tells us to do. And when we disagree with the ruling, the right thing to do is obey the judge's order and appeal until the last court tells us no. And because thousands of lawyers follow this basic rule every day, the rule of law survives. But right now, the rule of law is in peril because President Trump has decided he doesn't have to follow the court's orders he doesn't like. Sort of. It's complicated. He's refusing to comply, but saying that they are complying.
On Air Force One last night, he was asked, did his administration violate the judge's order?
I don't know. You have to speak to the lawyers about that.
But it seems we may have the clearest case of the executive defying a direct court order in American history. And it looks like things are only going to get worse. Now, as we've already explained, the ACLU got wind of a Trump plot to massively expand and fast-track deportations without a fair legal process. The Alien Enemies Act of 1789 is a controversial law that purports to allow the government to deport foreign nationals during wartime. But Trump has invoked this act to justify deportations during peacetime. And Trump asserts that the act allows him to deport certain immigrants on the grounds that they are members of a Venezuelan gang. Of course, so far all this has happened without any due process whatsoever, meaning that we don't know that any of these people are actually members of a Venezuelan gang. And as long as the president says that they are a member, they can be deported, actually renditioned to a foreign country that they're not even from. And that means that it's possible that even American citizens could get swept up in this whole process. Which is why we spent an entire video going over how terrible all of this is. But the ACLU filed an emergency lawsuit asking a federal judge to stop the renditions. On March 15th, U.S. District Judge James Boasberg issued a 14-day deportation of over 200 Venezuelan immigrants. The judge even told the government that if the planes were in the air, they needed to turn around. And despite that order, the administration proceeded with the deportations. At a hearing, the DOJ lawyers asserted that Trump had the power to deport immigrants and that he could keep his reasons secret from the court. And the judiciary exists to interpret and enforce the law, ensuring that the executive and legislative branches operate within constitutional limits. But the Constitution contains a potentially fatal flaw. It doesn't give the courts a way to enforce their orders. That's why the system depends on all of us recognizing the court's authority. And when the executive branch defies a court order, it effectively declares that the judicial authority is meaningless.
Yeah. It's just like when you turn around and say like, yeah, I'm not following the court orders, then like the entire system falls apart. Because it's entirely predicated on the persuasive power that the judiciary has. It's the only thing that they have, which is why I was very critical of the Supreme Court's previous decisions not exercising its persuasive power because they were worried that Trump could simply ignore it, signaling that the judiciary has no power whatsoever. Does that make sense?
Potentially eroding the rule of law. And it seems the Trump administration's actions have finally triggered the constitutional crisis we've been dreading all along. So today we're going to talk about what happens if the president ignores a direct court order. Schoolhouse Rock laid this all out for us.
No one heart can be more powerful than any other is. Each controls the other, you see, and that's what we call checks and balances.
And that's a pretty nifty system when it works. But Trump is theoretically not the first president to face off with courts. Presidents like Andrew Jackson and Abraham Lincoln are often cited as examples of leaders who defied judicial authority. However, the myths surrounding their actions don't quite match with the reality. What Trump is doing right now is putting us in completely uncharted waters. For example, in Worcester versus Georgia, the Supreme Court ruled that the state of Georgia could not impose its laws on Cherokee land. And that case contributed to the horrible episode in American history known as the Trail of Tears, where thousands of Native Americans were forcibly relocated. President Jackson criticized the court's ruling, and he allegedly said that Chief Justice, quote, John Marshall has made his decision, now let him enforce it. But this quote is almost certainly apocryphal. Most articles about the presidency and the rule of law conclude that Jackson himself defied a court order, probably because of this probably incorrect quote. Jackson supported Georgia's defiance of the Supreme Court, and he did not send the marshals to enforce the Supreme Court's order. But it's a myth that he defied the court himself. Similarly, Lincoln is often thought to have defied the courts when he suspended habeas corpus during the Civil War. In the case of ex parte Merryman, Supreme Court Justice Roger Taney considered whether to grant a habeas petition by John Merryman. Taney was sitting as a circuit court judge at the time, so this wasn't a Supreme Court case. But the military accused Merryman of operating a secessionist terror cell. When he was arrested, he filed a petition for habeas corpus, and Taney ordered the general in charge of Fort McHenry to appear at the hearing and to bring Merryman to the hearing itself. The government suspected Merryman of blowing up train tracks to prevent Congress and federal officials from reaching Washington, D.C., which would have cut D.C. off from the rest of the Union and could have altered the outcome of the Civil War.
Like, I'm thinking of Brown v. Board of Education, or even in that situation, it's like, it's states themselves refusing to abide by the precedent set by the Supreme Court. This is a direct action that the Supreme Court is making a demand over, and the only person that would enforce this action is the federal government. It completely undermines the checks and balances if the federal government refuses to follow. It's a fairly direct destruction of the any kind of power that the judiciary has.
When a U.S. Marshal tried to enforce the order to bring Merryman to court for a hearing, the military refused him entry. Judge Taney ruled that the government should have brought Merryman to court, President Lincoln or the general who had custody of Merryman to release him from confinement. Instead, he wrote an opinion that Merryman should be released. He asked the president to consider it, and then he served the opinion on President Lincoln. The entire case was over in 48 hours, and historians don't know if Lincoln was aware of the proceedings while they were happening. Merryman was eventually released on bail and wound up dragging out his treason trial until after the war ended. But the point is that Presidents Jackson and Lincoln did not directly ignore court orders in the way that the Trump administration seems to have been doing in these deportation cases. Now,
yeah, this is why I said it's like a little bit different, where it's the federal government not enforcing states' capacity to do harm versus the federal government directly refusing to answer to the judiciary. I guess it's in practice, it's the same outcome, kind of, but like it is new.
Now, before we get into the court's options, it should be noted that it's not always easy to determine if the government has violated a court order. Sometimes the government violates the spirit of an order without violating the letter of the law itself. And there are two recent examples of this. On March 6, President Trump issued an executive order suspending the security clearances for the law firm Perkins Coie, limiting the attorney's access to federal buildings. U.S. District Judge Beryl Howell granted a temporary restraining order against the enforcement of this order. But Trump then issued an executive order targeting another prominent law firm, Paul Weiss, using the exact same language enjoined by Howell. Now, we can argue that the Paul Weiss order will be enjoined for the same reason that the government should not have tried it again, and that's true, but Judge Howell's order doesn't apply to other law firms. As a side note, this is one of the reasons you should not be able to pass a bill of attainder in Congress or create effectively a bill of attainder by executive order either, but that's a topic for another video. But in any event, the two executive orders are different. One targeted one law firm and the other targeted a different law firm. So the first TRO doesn't apply to the second executive order. And Trump seems to be playing the same game with transgender people in prison. In January 2025, President Trump issued Executive Order 14168, mandating, among other things, that transgender women incarcerated in federal prisons be transferred to men's facilities and denied access to gender-affirming medical care. On February 25th, federal judge Royce Lambeth granted a preliminary injunction blocking the transfer of these transgender women to men's prisons and the termination of their hormone therapy. The Bureau of Prisons subsequently proceeded with transferring other transgender women to men's facilities, but kept the three named in the TRO where they were. While headlines said that the Trump administration ignored a court order, this probably isn't true. The administration complied with the letter of the order by not transferring the three named women to a men's prison, but now they face additional lawsuits on the
It's so fucking evil and gross,
same
dude.
grounds
Holy
related
shit.
to all the other people that they transferred. Now, while the courts have the right to say what the law means, and that goes back all the way to Marbury versus Madison, the Constitution doesn't give courts a clear way to enforce orders against a rogue president who refuses to follow the spirit of the orders or just outright ignore them. Now, if you are illegally renditioned to a foreign country, you're probably going to want a good lawyer. But if you want a great lawyer, let my firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, You need the Eagle team, so click below. So when the government arguably disregards a court order, judges usually start by clarifying their orders and giving the government a chance to comply. This is happening right now in dozens of cases involving Trump's illegal executive orders. If the government doesn't comply, then judges may find them in contempt. And one thing you'll notice about everything that we're talking about here today is that this is a slow process. Courts have to lay a factual and legal foundation, and they have to slowly ratchet up the pressure over time. If they don't lay the correct factual or legal foundation, or they move too fast, then all of their decisions might get overturned on appeal. But generally speaking, contempt of court is defined as any act which is calculated to embarrass, hinder, or obstruct a court in the administration of justice, or which is calculated to lessen the authority or dignity of a court.
Yeah, you could literally, like, that's the awesome power that courts technically have. Like, this is why it's insane. If the Trump administration is like, no.
And when distinguishing between the types of contempt, there are two broad categories: criminal versus civil, and direct versus indirect. Now, civil contempt is remedial rather than punitive, and serves only the purpose of the party litigant, and is intended to coerce compliance with an order of the court or to compensate for losses or damages caused by noncompliance. When civil contempt is at issue, the party moving for a contempt finding bears the burden of showing by clear and convincing evidence that contemptors violated a specific and definite order of the court. And there are two types of civil contempt. Coercive civil contempt aims to compel someone to comply with a court order rather than punishing them for disobedience. The court imposes sanctions like fines or jail time to pressure a party into obeying the order, and the contemptor in a coercive civil contempt action is said to possess the keys to their own cell, because they can immediately end the sanctions with simply complying. The classic example is a witness who refuses to testify despite a court order. That person may be jailed until they agree to testify. And the other kind of civil contempt is called compensatory civil contempt, where the purpose is to award compensation to the party harmed by the contemptuous behavior. For example, if a company violates a court order and causes financial harm to another party, the court may order the violator to reimburse the injured party for the losses. But like private parties, government agencies and officials may be subject to civil contempt. But if the initial burden is met, then the burden shifts to the contemptors to demonstrate why they were unable to comply. Now, Trump officials have been held in civil contempt of court before. In 2015, the Obama Department of Education fined Corinthian colleges $30 million for defrauding students and misusing federal funds. A court directed the Department of Education to stop collecting on the loans, but when the Trump administration took over, the Department of Education continued to bill who Corinthian defrauded. Education Secretary Betsy DeVos defied a court order to stop collecting student loan payments. And a federal judge ruled that, quote, "There is no question that defendants violated the preliminary injunction. There's also no question that the defendants' violations harmed individual borrowers who were forced to repay loans either through voluntary actions or involuntary methods, offset from tax refunds and wage garnishments, and who suffered from the adverse credit reporting. Defendants have not provided evidence that they were unable to comply with the preliminary injunction, and the evidence shows only minimal efforts to comply with the preliminary injunction." The court found DeVos in civil contempt and fined the agency $100,000, which was paid to the impacted students. Now that takes us to criminal contempt. The primary aim of criminal contempt is vindicating the authority of the court. To prove criminal contempt,
jail his ass. Put his ass in jail.
The court must show that a clear and specific court order was in place and the contemptor knowingly and willfully violated the order. Since criminal contempt is punitive in nature, the standard is beyond a reasonable doubt. And the court's authority to impose criminal contempt sanctions come from Rule 42 of the Federal Rules of Criminal Procedure. Rule 42 states, "Any person who commits criminal contempt may be punished for that contempt after prosecution on notice." And criminal contempt of court is generally recognized as direct or indirect, depending on where and how the contemptuous behavior occurs. Under Rule 42A, contempt is indirect when it occurs out of the presence of the court, requiring the court to rely on the testimony of third parties for proof of the offense. If this is the case, the court must hold a separate hearing to determine whether the contempt occurred. For example, if someone failed to pay court-ordered child support, this would be indirect because the failure happened outside of the courtroom. And the same is true if someone failed to turn over subpoenaed documents or disobeyed a restraining order, but contempt is direct when it occurs under the court's own eye and within its own hearing. The judge can immediately see or hear the contemptuous behavior and can punish it immediately. Direct contempt includes exactly the type of conduct you would expect: a witness openly refusing to answer a judge's questions, or a party disrupting court proceedings with outbursts.
One more word out of you, Mr. Reed, and I'll hold you in contempt. I hold myself in contempt!
And here, regarding the case of the putative Venezuelan migrants who were renditioned to El Salvador, if Judge Boasberg is considering criminal contempt to punish the government, then he would have to weigh whether the government's actions were direct or indirect. The failure of the government to turn the planes around happened outside of his courtroom, so it would qualify as indirect contempt. However, I suppose that there's an argument that the DOJ lawyers were in contempt of court because some of the contemptuous conduct occurred inside of the courtroom. The parties took a break to determine whether the airplanes had already taken off, and the judge orally told them to turn the planes around, and the lawyers indicated that they would comply with the order. But direct contempt provides for summary disposition. No federal court is going to punish the government without a full hearing, especially since the government will appeal any contempt order. And it's better for all parties to have a complete factual record justifying whatever the court decides to do, whether it's civil or criminal. The problem is that the government is trying to prevent Judge Boasberg from undertaking the fact-finding necessary to develop a complete record about the flights to El Salvador. The judge has repeatedly asked the government to answer questions, but the government has refused to provide any answer. And then, sensing that Judge Boasberg was moving closer to a contempt finding, the administration suddenly claimed it was considering invoking the state secrets privilege. This prompted a new round of back and forth between Judge Boasberg and the government, which finally ended with the government asserting it had a national security reason to refuse to answer any questions about the flights. But it certainly seems like the administration's privilege argument seems to be made in bad faith. They didn't raise it until the judge continued to investigate, and a lot of the information about the flights is already in the public record, including a bunch of propaganda videos that they made at the time, and the first reference to privilege came from a declaration by an ICE official in a
I think none of this matters of the Supreme Court ruling saying his order was wrong. It still matters because the Supreme Court, just like the lower courts, have, I mean, it's still a part of the judiciary. So it technically still matters right now, depending on whether or not Trump will decide to do the thing, to do the damn thing that is, that will eventually turn the U.S. Constitution into a piece of toilet paper. You know what I mean? Like, it's just, this is, I guess they could just keep stalling. That's usually how you can effectively refuse to comply with a direct order from the Supreme Court. Just kind of ignore it. I mean, this is one of the many cases that the Trump administration's actions have created that is boundary breaking, precedent setting, truly the next stage of American fascism. This is what I've been talking about. On the immigration front, this is one of the many court cases. On the First Amendment side, also tied back to immigration, it's yet another incredibly important court decision. Like, this is the moment where either the institution starts serving the fascist agenda and the rules, the legality doesn't matter anymore. It's more so an argument about morality. Like, this is the moment where, is slavery legal or not? Okay, that's basically it. You know how we talk about how laws don't mean anything if those laws are directly and openly unjustifiable? And we point to the racial purity laws in Nazi Germany or slavery laws in the United States of America. This means, are we crossing the legal Rubicon or not? Are we just completely dismantling any persuasive power that the judiciary has, therefore completely dismantling the judiciary, or, I guess, turning it into a puppet of the federal government, which in some instances it has acted like that regardless. But I mean, this is a very important moment, I think, in American history, depending on what the Trump administration does.
Regional office in Texas who would not have been privy to any cabinet level discussions. Now, Secretary Rubio, AG Pam Bondi, and DHS Secretary Kristi Noem say that the information about the flights must be kept secret for sensitive national security reasons. And they claim they can't even show it to the judge in camera, meaning privately in chambers, because Trump's policy goals must never see the light of day. Of course, irony of ironies, they made these arguments just days before Secretary of Defense Pete Hegseth and other high-level cabinet members leaked active war plans by including the editor-in-chief of The Atlantic in their Signal group chat. And then they claimed none of that information was classified or sensitive national defense information. Now, notwithstanding the onslaught of scandals coming out of the Trump administration, state and federal officials rarely screw up so badly that a judge finds them in criminal contempt. But when a public official flouts the courts and inflicts serious damage on other people, the courts often have no choice. For example, former Maricopa County Sheriff Joe Arpaio established a policy and practice of racial profiling Latino drivers.
By the way, this video is outdated at this point because, I mean, there's still a lot in it that's important, especially at the beginning where he talked about like the historic precedent for finding yourself in violation of Supreme Court orders. But the reason why it's, I guess, technically outdated is because as of this moment, as of a couple hours ago, the Supreme Court did decide unanimously to return the Maryland man that was falsely sent to El Salvador, despite having a previous court ruling that protected him because he had a withdrawal order.
Drivers and asking them to prove they were legally entitled to be in the country. A federal judge ruled the
Am I missing something? Are all this irrelevant per Trump versus U.S. presidential? No, this doesn't render that moot.
Policy was illegal, but Arpaio directed his deputies to ignore the court and continued to racially profile drivers for 18 months. The sheriff's office illegally detained.
That's not what the SCOTUS said, though. They said that the admin should facilitate the process of bringing him back, but did not require that they do so. There is a video from earlier today.
So remember when we said the Trump administration,
which I have on the docket as well. The video that I had on the docket already, which was this, what do you call it? Which is this one, which is SCOTUS, due process in theory, deportation.
Snatched an unknown number of immigrants from the streets of America without any due process, no hearings, no trials, and renditioned them off to detention centers in Trump-friendly jurisdictions, then sent them on flights to a Salvadoran torture prison where they will be placed under the watchful eye of the guy who describes himself as the coolest dictator in the world. Well,
I mean, I guess the verbiage is like must facilitate, but I mean, that's pretty clear, no? Must facilitate the return. Like, what are they supposed to do? Must return? I mean, they said must. SCOTUS also referring it back to district court to further clarify what facilitate return means. This is far from over. Facilitating without a deadline means nothing. They could just delay for years. No, I know. It could be ass covering. It could be ass covering from the Supreme Court, so that they say, well, we gave the lawful order, but then we left it in an open-ended manner, so they could just turn around and say, oh, we're trying to facilitate. We're following the lawful order of facilitation. That doesn't mean we're actually returning him. They can hold off on doing it. Yeah, new Supreme Court order requiring U.S. to facilitate return of Kilmar Abrego Garcia from El Salvador could open the door to similar legal claims by those Trump deported last month under the Alien Enemies Act. The language is vague, but logic would suggest they mean bring him back. Yes. But there's two different points here that are a matter of that could be up for contention. One, the fact that CCOT is in a sovereign nation, totally independent from the United States of America, which clearly is a legal argument that they're going to entertain. Okay. And the second part of the problem is, you know, they'll claim that they are facilitating the return, but facilitating the return can mean tomorrow. It can mean 3 years from now. It can mean never. It was part of the reason why I said that the Biden administration, for example, had the power to de facto delay student loans. That is directly the power of, that's directly within the power of the executive. They can't outright, let's say the Supreme Court says you can't outright abolish student loan debt, but you could technically delay student loan debt permanently. It's a power that they have. It's a power that they've used. It's a power that they used during COVID. It was a matter of the Biden administration refusing to use that power that they had that stopped them from doing so. So I don't know. Decision is unanimous, by the way, and it suggests someone held overseas can still be given due process. Yeah, will require the Trump administration to facilitate the return of Kilmar Abrego Garcia. How much infighting in the Supreme Court prevents outright corruption? What? He cooked. CNN analysts are saying that El Salvador cooked. Just say no still, and the U.S. is still facilitating. Yeah, I saw the Mahmoud Khalil memo as well. It's right here, which is insane. This is also complementary to the thing that we're discussing. As you guys know, Mahmoud Khalil was also kidnapped and black bagged from Columbia University, where he resided as a green card holder for seemingly no crime whatsoever, but simply an awesome power that previously, at least as far as I understand, not really been utilized by the Secretary of the State. The justification for why he was black bagged was that he was determined to be a threat to American national security. The real reason as to why they were doing that, or at least the evidence they suggested as to why he was a threat to national security, was, well, as follows. This is what they said. Information provided by the DHS, ICE, HSI regarding the participation and roles of Bleep and Mahmoud Khalil in an anti-Semitic protest and disruptive activities which fosters a hostile environment for Jewish students in the United States. My determination is also based on citations for unlawful activity during this protest. The public actions and continued presence of, I don't know why this is censored, but and Khalil in the United States undermine U.S. policy to combat anti-Semitism around the world and in the United States. In addition to the efforts to protect Jewish students from harassment and violence of the United States, consistent with Executive Order 14150, America First Policy Directive, to the Secretary of State, the foreign policy of the United States champions core American interests and the American citizens condoning anti-Semitic conduct and disruptive protests in the United States would severely undermine the significant foreign policy objective. No hard evidence whatsoever, but vague generalizations. Incredibly, incredibly dangerous. I don't think that the judge that required hard evidence will see this as like reason alone to justify the deportation. After the immigration judge in Mahmoud Khalil's case ordered the government to provide evidence to justify deporting him, this is what they filed. This is from Janine Yunus, Palestinian American civil liberties free speech attorney. I've been a lawyer for 14 years, she says, and a criminal defense lawyer for 9 of those years, and I've never seen anything like this. Totally nebulous, vague allegations about involvement in anti-Semitic protests and disruptive activities without any specific attributions of unlawful activity or even anti-Semitic speech to Khalil himself, which in any event is protected. The U.S. rightly does not have hate speech laws. That's the other side of this. Even if they were to ascribe anti-Semitic speech directly to Mahmoud Khalil, this would not actually be reason alone to fucking deport him or to revoke his green card. Do you understand? You can't do that. That's why I keep repeating, and I stress this, the importance of this. The First Amendment protects you from exactly this, government action. This is why you can't just like deport Nazis just because they are Nazis. Although you might want to do that, you literally cannot do that. This is precisely the reason why the First Amendment is the reason why you can't do that. So this would destroy the First Amendment. It's just, it would destroy it in its entirety. There would be no more First Amendment. This would be the boundary-breaking, precedent-setting case that would erode the constitutional protection that every citizen and non-citizen alike has in the United States of America. In the U.S. and all civilized societies, if the government is going to punish someone under the law, it had better provide evidence for specific forms of unlawful activity by the individual they're targeting. Not only has the government entirely failed to do that here, but it's obvious its case is predicated on punishing First Amendment protected speech and protest. Like even with Charles Manson, for example, you have to provide direct evidence that Charles Manson was influencing people to take action, right? Even in RICO cases, you have to basically tie back with hard evidence how the influence of the person who is in charge of the criminal organization and their opinions and their actions are basically are basically why these sorts of crimes are occurring. Okay? You can't just simply go, yeah, this guy is a bad guy. I've decided he's a bad guy. I decided he did a bad thing, so we're deporting him. You can't do that until now. Yeah, this speculation, I think, is not incorrect. My theory on what happened, Beitar, Canary Mission Fed senators fabricated lies past the DHS and ICE. Deportation orders were issued without vetting. They thought Khalil was on a visa, not green card. Now they look incompetent and have to reconsider their sources. Janine speculates further, says, agreed. I agree with the speculation, by the way, because they literally initially stated that that Mahmoud Khalil was on a student visa. That is too large of an error to make. It is shocking. And then they just continued along with it. Now they box themselves in and won't admit they made a mistake and maybe should have done a little work before accepting at face value the words of an explicitly genocidal terrorist group. Yeah. Anyway. Can you please boost this message for Chad to see the Encampments movie this weekend? Maybe the last one in most places, unless more people go. His center's Mahmoud Khalil and his work is very good. Yeah. What is this? A disgraced former cop proved the report claiming Andrew, the gay makeup artist, was a gang member based on mom and dad tattoos. This cop has been caught lying and was fired after drunk driving into someone's house, but he has now apparently been given the power to single-handedly sentence innocent people to life in a torture dungeon. Yeah. Is Beitar run by the guy trying to have sex with Brace Belden in the park? Yes. Or is run by that guy.